Okay. So we'll do a countdown. We'll go three, two, one. Um, cool. I am here with Rich Goldstein, and we met actually at the Prosper Show last year, the trade show for Amazon sellers in Vegas, and we got to talking about IP around Amazon products in particular, and I think with a lot of things, a lot of products coming out of China to the markets, and sellers trying to get every competitive edge they can get. IP is going to become increasingly important. So, Rich, thanks for joining us on the show.
Absolutely. Thanks for having me.
Yeah. So I guess, well, first of all, like these office walls, I'm not sure they seem to pick the same off-white color for all the office walls. Just seems to happen. Not sure why they do that, but I just noticed on screen this is this is what we're dealing with here.
Lots of white.
Yeah.
Yeah. I think it's to keep us from going insane.
Oh, okay.
Being that we're stuck in this spot probably for much of our lives.
Yep.
So they pick the neutral colors to just try and keep our sanity amidst all the insanity that we deal with every day.
So
Maybe.
Okay, so speaking of insanity, okay, what sort of if I'm an Amazon seller in the market today, what sort of stuff am I dealing with in terms of patents and IP? I mean, this is something that some people watching may not have even thought about as an issue.
Well, I say the two main ways in which Amazon sellers come upon patent issues or potential patent issues is first of all, they get ripped off. I mean, people are ripping off other Amazon sellers, other listings all the time. And so when you have a product that's going well, that it's selling well, and then you see that you've been suddenly ripped off and your sales drop, you begin to wonder, well, what can I do to prevent this? And in most cases, if it's already happened, if it's a listing that's already in place, it's probably too late to do anything to protect yourself. But it's that experience, it's that happening that has people wonder, hey, is there something more I can do for the next great product that I come up with, or the next great product that I list, that could help me in the future, that could prevent me from kind of putting a lot of time and effort into developing a listing, into getting something selling well, only to have other people come in and rip it off. Like, that just sucks, and people really want to avoid that. And so people are getting creative and using IP to help them to maintain their market share, to help them to keep their listings exclusive. And so that's one side of it. So one side of it is that Amazon sellers are increasingly wondering what else they can do to protect themselves. And then the other side of it, though, is they're seeing more and more IP complaints. And IP complaint is where someone else says, hey, that's my product. I have a patent on it. I have a trademark on that name. And so so the seller gets an IP complaint, all of a sudden their listing gets shut down. And in a lot of cases, it's an unfair IP complaint, or it's baseless, and they get shut down anyway. And it's a difficult situation. But there's a lesson to be learned here. And the lesson is that Amazon has been deferring to IP owners. If you have a patent and you say, hey, this is my patent, and these other people are infringing it, Amazon doesn't investigate heavily. They tend to shoot first and ask questions later. They tend to shut down the listing and then leave it to the parties to work it out. So the lesson to be learned from that is if Amazon is deferring to IP owners, then it pays to be an IP owner.
Mm-hmm.
So it pays to acquire IP. It pays to acquire a patent if it's possible to do so.
Okay. So, yeah, if we were to look at it initially, you could head off this issue by securing some IP early in the process before the product even launches or gets to market. So, what does that look like?
Well, yeah, I mean, and that's critical right there, is to secure it early before the product comes to market. Generally, one thing that most people don't know about patents is that you lose the right to patent by making it public before you apply. So
what does that mean, make it public?
it means a bunch of different things, and it gets rather technical, but certainly putting it on sale on Amazon is considered a public disclosure.
Okay.
And so once you do that, you immediately lose your rights in most of the world. And in the U.S., technically under the right circumstances, there's a 1-year grace period, which means worst case scenario, if a year goes by that it's been public, then it's absolutely too late to patent it in the U.S. And it pays to figure out at an early stage whether it's worth patenting or not. So not everything should be patented. Not everything can be patented. Things are going to be ripped off. Not everything that's going to be stolen or ripped off is worthy of protection. So there's an analysis to be done of whether it's even worth doing anything in terms of protection. But the critical lesson is you do it in the beginning. You do it early. Because too many people wait for a long time. Too many people have a product that they've been selling for 2 years and they are doing really well with it, and they see that people are starting to rip it off, or they have a feeling that it's about to be ripped off. And then they come to me and they say, well, I need to get a patent on this. And I have to give them the unhappy news that it's just too late. So if you're going to do it, you do it in the beginning.
Okay.
But and if you decide not to do it, that's fine. And then go about your business. You do everything that you can to optimize your listing and all the other hacks and tricks that I know that you love telling people about, to how to really make the most of your Amazon selling experience. Focus on all that stuff. That's fine. So make the decision early of whether you're going to do something about protection, and then don't look back.
Right. Fair enough. Okay. And so under what circumstances does your product qualify for some IP protection? Because I know a lot of people are sourcing products from China, and that's a pretty stock item. They may put their brand logo on it. They may make some minor physical tweaks, but at what point do you go from being something that you can't protect to being something that's proprietary?
Okay, yeah, great question. And so as far as and different types of IP protection protect different types of things.
Okay.
So for example, if we're talking about names and brands and branding and logos, that's trademark. So in terms of trademarks, if you have a distinctive name for the product, then you might want to get a trademark on that. And also a logo can be protected with a trademark. One of the advantages of having a trademark with Amazon, well, you don't have a trademark with Amazon, but one of the advantages of having a trademark when you're selling on Amazon is that you can enter the brand gating program,
Right.
where Amazon will effectively stop other people from using that same mark in your space. And the way that you get into the brand gating program is you need to have a registered trademark. So, and in order to get a registered trademark, you need to apply with the United States Patent and Trademark Office. And there are different types of trademarks, and this is a very important distinction for Amazon sellers, is there are word marks and design marks. So a word mark is for the name itself, for the name of the product. A design mark is more toward the way in which the name is presented, perhaps with the logo. The point is, if you apply for a design mark, from everything I've seen, Amazon won't let you into brand gating with a design mark. It has to be the word mark.
Okay, so not just a stylization of font or anything, but it needs to be a trademark on the name of your brand. Is that
exactly?
Okay, is that through the USPTO
Exactly.
or how to
Yeah, that's through the USPTO.
Okay.
But there's different types of marks you can get through the USPTO, and I'll tell you why this comes up. Is sometimes with in order to get a trademark, the name has to be distinctive, which means that it's a type of name that people would associate with a brand and not just with a generic product. A little confusing, let me explain. So aspirin is generic. It's just, that's what the product is, it's aspirin. People don't think of aspirin as a brand name, it's just how you name the product. So something generic or something descriptive, that's not trademarkable. And so sometimes people have a very descriptive trademark, like fitness gym, right? So that pretty much describes what it is, but maybe you open the chain of fitness gyms, and that's what you call it. And so you want to do the best you can to get a trademark. A lot of times, the best you can do is a design mark. You have a logo for it, and yes, it says fitness gym, and so fitness gym is in the trademark in the mark listing as it's listed in the application. But if it's filed as a design mark, first of all, that's how you get it through, is by saying, well, I'm not really trying to protect fitness gym. I'm trying to protect this design with the logo and all. So people get a trademark like that. And then if they went to Amazon and attempted to gate it, Amazon would say, no, you can't have it. You don't actually have the trademark on fitness gym. And kind of a bad example, because you're not going to sell that at Amazon. But imagine if it was a supplement and it was something like, what's a type of supplement people take, like creatine. And so it was like, I don't know, whole creatine. So it doesn't really make much sense. It's just very descriptive of what it is, or natural creatine, right? They want to protect that mark. If they did a design mark to get past this descriptiveness problem, you're never going to get brand gating. Okay. So very important. If you're going to do a trademark, make sure that it's a word mark.
Okay. And I guess it helps if your brand name is something creative or doesn't use sort of generic stock words.
Exactly. If you're going to pick a brand name, pick something that's creative. Right. The more arbitrary it is, right, the more likely it is to get a trademark and to have a strong trademark. And a strong example of that is Apple computers, right? When Apple came up with the name for their computer company, when had Apple ever been associated with a computer? Mm-hmm. It's not like a term that when people are talking about computers, they use. It's not like fast CPU computers, right? It's not a descriptive term. Mm-hmm. So since Apple was so arbitrary with regard to computers, it became a very strong trademark, because the competitors don't need to use that word Apple in any of their sales literature unless they're trying to confuse the public into thinking that they're Apple. And so the more distinctive the name that you come up with, the better trademark protection you're going to get. So it pays to do that analysis in the beginning when you're coming up with a product, is to have it not just be something which is just so blasé ordinary, because then you're going to not only run into this distinctiveness problem, but you're probably going to have a lot of other people that are doing the same thing that have similar names, and you're never going to get it protected.
Okay. So, yeah, good arbitrary brandable term on the trademark, and that opens the gate to the brand registry program. So that's good to know.
Yes.
In terms of the physical, so the physical product, right? I'm assuming that if you're sourcing something from China and there's not a lot of physical form factor differentiation, it would be hard to get a patent on that. Is that right?
Yes, and just one thing about that too is if you're sourcing something from China and you're finding a product on Alibaba and you're about to sell it, you can't apply for a patent on that. It needs to be something that you actually invented. Okay. So white labeling a product, even if no one has applied for a patent on it, that doesn't give you the ability to apply for a patent. If you take something that exists and you have your own modifications to it, those are the things that you would protect. Those are the things that you could apply for a patent on.
Okay.
Okay.
So yeah, I'm trying to understand where the line is, because it's a change in materials or slight physical modifications. There's probably some sort of line that you cross where it's differentiated enough where it's really your own invention, but I'm not sure where that line is. I guess so.
Let's talk about that line. Yeah.
So you guys do this as a service, right? So I imagine people will come to you with the product and they're looking to get protection on it. So you must have to turn certain cases away and accept other ones. So.
Yeah, exactly. Well, let me give you some guidelines about that in terms of where the line is. So first of all, there's two main types of patents that we would be considering with regard to protecting a product. Okay. There's a design patent and a utility patent. Utility patent is when you have functional differences between things that already exist and what you've come up with. And so basically what you're protecting is some type of structural configuration, some type of new arrangement that is for a functional purpose, okay? And in terms of that, and in terms of where the line is of how new it needs to be, it has to be different in some way. That's called novel. Then it also has to be non-obvious. So non-obvious basically means that it's kind of outside the range in which people in the field normally look. So if someone is designing a certain type of product, like they kind of know, like generally what the different possibilities are. Like they know if it's a container that there's different types of caps, that there's a screw-on cap, that there's a flip type cap, or a sport bottle top, or like there's a bunch of different types of container caps that you could use. So if, for example, in a certain type of container, no one has seemed to have ever used a sport bottle top before, it still wouldn't be patentable because it would be considered obvious. People that design containers know that there are a lot of different ways you can have a container close, including screw-on caps and flip tops and something that you break off a single time. So then it would be obvious to someone in the field to just adapt that flip cap onto the existing water bottle. So things that are obvious to people in the field, that's not patentable. So that's where the line is. Now, is it a bright line? Probably not. And what I mean by that is it's the type of thing that people can differ in opinion on sometimes. It's like, well, is it obvious or is it not obvious? But usually just changing the materials of something, or changing the size, selling something in a small size where it's never been offered in a small size, that's going to be obvious. So we call it textbook obvious because it's just in almost every case. But a lot of times that's what I give clients guidance on is, well, is this something that's going to likely get past that obviousness requirement? And now in order to figure out if something's obvious or not, what we really need to do is find out, well, what are the closest things to it? Because until we know, like, what the closest things are to it, it's like obvious compared to what? So you see what other people have done that's close to it. You say what is different about it, and then you say, well, is that difference obvious or not? So that's typically the analysis we're doing when we're looking at a project to see if this is something that's patentable. So we do research to see what's close, and then we can decide whether it's obvious or not. And that's also the thing that we often argue with the patent office about, is we'll submit something and they'll say it's obvious, and we need to argue and show them that it really isn't.
Yeah. Okay.
So that's on the utility side of things. And again, so utility patent is when you have a functional difference with something. So it's got a different functionality to it, and that's what we're seeking to protect. And in most arenas, other than Amazon, utilities tend to be the most valuable patents because they protect the concept rather than just a specific look for something. In Amazon, it's actually reversed, and I'll explain why in a few moments. So now there's the other type of patent, which is a design patent. And a design patent is just for the physical shape of an object. It's for the ornamental appearance of it. So you have a product, which is, it's just a container, right? There's nothing different functionally about it. But maybe it has these wavy lines in it, and it has a certain overall shape to it. This could be the subject of a design patent. And it probably is. And so now a design patent is just for the appearance of the product. And so now traditionally, we tell clients it's always better to have a utility patent because utility patent protects the concept. Design patent, they change the way that it looks, then it's not going to be infringing the patent, and it's not going to give you much room to stop your competitors. But on Amazon, it's different because let's take a look at how things work on Amazon. If you create a product that has a kind of distinctive shape to it, you apply for a design patent, you get a design patent for that shape, and then you see competitors with similar products, you send Amazon an IP complaint, and you say, hey, that's my design, and here's my design patent. Amazon looks at it, and they don't give it a high-level analysis. I mean, you don't have patent attorneys reviewing these IP complaints. Mm-hmm. They see it, and they see your product, and they say, well, looks the same, shut down the listing. So Amazon will shut down a listing for a design patent that looks similar. Sometimes they go a little bit too far with that. I mean, well, often they do. And though it pays to be the guy with the design patent, because they're not doing a high level of analysis on it, and they're saying that it looks similar, therefore we'll give the IP owner the benefit of the doubt. We'll give the patent owner the benefit of the doubt. So if you're the patent owner, that works in your favor. On the other hand, if you have a utility patent, Amazon isn't so quick to shut down the listing. And now it's interesting because utility patents are typically more valuable. Right. Utility patents typically cover more of the concept. The only thing is, again, you don't have people at Amazon with that level of experience to review these IP complaints. So they typically won't shut down a listing based upon a utility patent without some pretty clear evidence, which may be an actual judgment in court or a consent judgment. But essentially, it's not as easy with a utility patent. So like I said, it's kind of flipped. In the real world, it's usually better to have a utility patent. In the Amazon world, it tends to be better to have a design patent. And the bonus is that design patents are a lot less expensive to get than utility patents. Like, utility patents are labor intensive. When I write a utility patent application, it's like a 30-page document with maybe 10 drawing sheets that are explaining every detail of the invention and how it's different from things that have been done before and why it's worthy of a patent. And so that's expensive. A design patent is all about presenting drawings following all of the patent office rules. And so it's mostly about presenting the drawings. And there's judgment that goes into how we present it and what we show and what we don't show and things like that. But still, it's a lot simpler, so it's a lot less expensive. So I tell a lot of sellers, if you have a product that's innovative, it pays to do a design patent. Might not pay to do a utility patent, but it pays to do a design patent for something that you think is going to be a good seller, a good listing.
Okay. What does it cost for each of those? Plus, if you could sort of itemize it with the cost with interfacing with the government, but also what it would cost to have you work on the project for them.
Yes, and so utility patent, typically the cost is north of $10,000. Mm-hmm. I mean, on the simple side, it's going to be $10,000 to apply for a utility patent.
Right, that's just to apply, right? It may not get accepted.
Yeah, just to apply, right. And that's and the majority of that is attorney's fees. The government fee, around $400 to $800. It's relatively insignificant compared to it. So just figure north of $10,000 for a utility patent. Okay. Design patent, typically a few $1,000s. And government fee, a few $100s again. So about a third to a quarter of the cost of a utility patent. Okay. Again, if it's a product that you see some real potential in, and it has a distinctive appearance, then it probably pays to do a design patent.
Okay. Okay. So say we do. Now, in terms of fighting things on Amazon later on, like is the most value you'll probably get out of the design patent than utility, then where does trademark fall in terms of importance on Amazon? We'd explained it, I just don't know how important it is.
Well, I guess it depends on what the tendency is for people to do in your field. So if you think people are going to kind of rip off your product and just sell something just like it, but they don't care about the name, then the branding isn't that important. I don't really know to what extent like copycat products care about copying the name. Mm-hmm. It's like, typically if they can get their listing to show up alongside yours, and it's just whatever it is, whether it's like like reading glasses or something, and they look similar, then the consumer, in my opinion, doesn't care too much about the name.
Yes, especially on Amazon. Yeah, I think that's true.
Yes.
Yeah.
But if it's a certain product that maybe the type of product that people buy repeatedly and want to look for the same product again, like maybe supplements or things of that nature, mm-hmm. where they're looking for the same supplement that they bought last time, then the branding becomes very important, because you want to make sure that other people can't start selling supplements with a name that's going to confuse the public into thinking that they're you.
Yep. Right.
They think that they're coming to make a repeat purchase and they end up buying your competitors. That's not good.
All right. Okay.
So I would say is you kind of try to imagine what the consumer might think and what they might care about. Is it the name, or is it the product, the way the product looks?
Okay. Yeah, and it also slipped my mind for a second there, but the trademark is necessary for brand registry, so that's probably something you need to do anyway.
Exactly. If you want that brand registry, and again, I think brand registry becomes important when people are likely to copy the actual name of the product.
Okay.
When it's less likely that they're going to do that in your niche, then it's less important.
Okay. Pricing on the trademark there?
Couple $1,000.
Okay. Again. Okay. So you'd be looking at maybe between, if you wanted the essentials, right, or of legal protection at least, you want the trademark, you want the design patent. You're probably looking at between attorney's fees and government fees, still under $10,000 for both of those. Could be.
Yes.
Right.
Certainly.
Right, yeah.
Another thing I want to say about trademarks too. So, first of all, when it comes to patents, don't ever try and do a patent on your own. It's not going to work. I work with some very intelligent, accomplished, successful people that try to write their own patent applications, and I look at it and I say, well, this isn't really a patent application, but it'll be helpful to me to understand what I want to portray about your invention. So when it comes to a patent, it's got to be done by a patent attorney. There's no question. When it comes to a trademark, it's somewhat possible to do it on your own, and a lot of people do successfully do trademarks on their own. So, but there are also ways in which you can go wrong with it. If you do the trademark on your own, it costs you a few $100s in government filing fees. When considering whether you're going to do it on your own, I think the biggest thing to consider is that there's a bunch of ways to do it incorrectly. And when you do it incorrectly, you're going to waste your time and a bit of money, whatever you paid in filing fees or what have you. But you might find out a year down the road that you have to start all over again. And then maybe at that point you end up hiring an attorney to help you with it. So the point is that it pays to, if there's value at stake, and if it is actually valuable for it to issue in due course, in other words, not hit some really unexpected or unfortunate hitches that really delay the process, then it pays to hire someone to do it. Statistics I've heard is that about 30% of the applications that are done by individuals are successful.
This is trademark, patent, or both?
Trademarks. Trademarks.
Yeah.
Patent, just forget about doing your own patent. I could tell you the reasons why in detail, but suffice to say, the point I'm trying to make here is less about patents and more about that, yes, trademarks, it is somewhat possible to do on your own, but if there's value at stake, then it pays to hire someone to do it. If you're starting a new business and it's very speculative and you're not even sure if you're going to use this brand name, then you might just file it on your own and see what happens. But that's really the point is value at stake. Make sure it's done right from the beginning.
Okay. Yeah, I guess my last question in this domain, and then we can sort of move on to when you're playing on Amazon and protection around that. Do you feel that say you are, it's early days in your company, you're not sure if you're going to use the brand, you're not sure if you're going to use this form factor for the product long term. You'd mentioned a year in public, at which point you can't probably file for a patent anymore, design or utility, right? Does the same apply for a trademark, or I guess?
No, it's different.
Yeah.
Let me explain. So with trademarks, there is no kind of bar where in terms of patents it's called a bar or a statutory bar, where the statute or law actually prevents you or bars you from getting a patent. When it comes to trademarks, there is no such bar. And so you could apply for a trademark 5 years after you're using it.
Okay.
And that's fine unless someone else gets in before you. So it's kind of like, and this actually happens quite a bit, is I see brands that have been selling products for years and they've never done a trademark. And then we go to look and someone else actually got the trademark like last year. Mm-hmm. And so now what would have been relatively simple process of applying for a trademark now involves canceling the existing trademark. So it's probably, what could have been a $2,000 registration now has become a $10,000 to $50,000 problem. So once you know that you're going to use a brand, it pays to apply. Yep. But you won't actually get shut out of getting that trademark just by you using it like you do over on the patent side, okay, where you might get shut out. Okay. The other thing that happens too is that when as time goes on, other people tend to get into the field, whether they get their own trademark or not, but you get a bunch of other people that are using that same or similar name. It then becomes too late because it's no longer distinctive. People are no longer associating that brand name with one particular company. And so now that it's not distinctive anymore, it's really not protectable, or it's not protectable in any strong way. And this is leaving the Amazon world for a moment. But if you ever have a business that you're considering franchising, getting a trademark is absolutely critical. I've seen so many companies develop themselves into a potential franchising model where they've built multiple stores, they have a great model, it's like, we want to franchise this. But at the point in which they go to get the trademark, they realize that they can't actually get a trademark on it. And if you can't own the name, it's really impossible to franchise something. So, if your business is one that you're considering franchising at any point in the future, absolutely critical to get trademark protection.
Okay, good. Okay, so let's say we've gone through the process, we've protected some of our IP, the product's selling on Amazon, and we get that first complaint. And from what you're saying, what I'm hearing is that Amazon will often defer to the IP holder, rightfully or not, and they shut down your listing. What do you do then?
Okay, well, first thing to figure out is whether it's a legitimate IP complaint or not. Right. Yeah. In other words, like, are you really infringing? Would you really be infringing? If you really would be infringing, then I think, you could try and maneuver out of it, but it seems like it pays to cut your losses if you're actually an infringer. In other words, if you're in the wrong in the situation. If you're not infringing, then recognize that, again, things are not being reviewed by IP attorneys or judges at Amazon. They're dealing with things in very simple terms. So you've got to make it black and white. You've got to make it, whatever argument you make to get past that shutdown, it's got to be so clear that a third grader would say, well, yeah, clearly it's not. It's clearly this is a bogus complaint, and so let's reinstate the listing. So it's got to be crystal clear. Now, one of the best ways to get past an IP complaint when it has to do with a design patent is by not coming up against the actual patent itself that's being thrown at you, but by looking at what came before it. So here's a principle. So, first of all, it can be very difficult to analyze a patent and what a patent stands for. So there's a shortcut. My favorite shortcut is that whatever was patented at the time that this person got the patent, it couldn't be what already existed. So even if you're looking at this bottle and you say, well, I don't know, like, mine looks kind of similar to it. It has those ridges in there, and so I could see that it could be infringing, but maybe I am and maybe I'm not. But then if you find a patent from 20 years earlier that showed that the thing that really makes yours similar to theirs existed 20 years ago. Like, so there was a design patent that had a bottle that had that similar feature, that had those wavy indentures in it. Then that's your get out of jail free card, because now you're showing, like, hey, like, mine might look similar to the patent that's being thrown at me, but it looks most similar to something that was in the prior art, something that existed before their patent. So when they granted this guy his patent, it couldn't have been about that, because that was old. So that's the best trick I've seen to getting around this problem with Amazon, is to find something that black and white shows that the thing that is similar about it wasn't theirs to begin with. It existed before them.
Okay, right. Okay. And are most of these claims on the... well, I guess when another seller approaches you with a claim, do they have to specify if it's design or utility, or it's just a complaint in general? There's one IP complaint umbrella.
Well, they should be listing patent numbers, or providing something that the complaint is based on. And so, looking at the patent, immediately you can tell whether it's a design patent or utility patent.
Okay.
The design patent numbers start with a D, for one, and then if you open up the document, it starts with it says on the top design patent. So. Okay.
Oh, I guess so. This is skipping back to the beginning of the chronology, but something you said reminded me of it. Is there do you check Google Patents or any sort of database for things that could cause trouble later on, just as you're sourcing?
Yeah, it absolutely pays to do that. Is to check Google Patents, and like there's a methodology that I use for this, and it's based upon this principle that I mentioned a moment ago, is that when you're looking at a bunch of patents, it's often difficult to tell what the patent stands for. So if you're sourcing a product and you see a patent number, first thing, you absolutely want to look up the patent number. I see too many people just stop when they see a patent number. A lot of times the patent's expired. And so once a patent expires, it's public domain, meaning that anyone is free to do exactly what's in that patent. So first of all, check the patent number. It may be expired and they just still have the patent number on there, because it tends to scare people away. They see a patent number, they say, oh, I can't do this. But if the patent has expired, then it's public domain. The other thing to do is you could start looking at, when you look at a patent, when you're on Google Patents especially, it says patent citations. And so these are other patents that the patent office considered when they were deciding whether to grant this person their patent. And so all of those are inventions that are relatively closely related, and all are things that came before. So if you look through those references cited, and on Google Patents, often you can click directly through to them. And if you see that it's that if some of these older patents show those critical features that really are the essence of what you want to make in your product, then that gives you the safety, gives you a green light to know that, hey, if I want to make a bottle that has ridges like this, I can. So it gets pretty complicated to figure out when you're infringing or not. But again, when you're sourcing and you're wondering, like, hey, do products like this, could someone have a patent on it? Like if I want to make staplers, and like, is there someone has a patent on the stapler? Well, if you find examples of patents that are more than 20 years old, then you know right off the bat that no one has a patent on the stapler. They might have a patent on some type of unique feature or some type of release button that releases staples that are jammed. And I don't know how many people really use staplers anymore. Kind of dating myself even with this example. But the point is, when you're able to find examples of the concept you want to do, then at least you know that no one has the rights to the concept itself.
Right. Okay.
Then you have to be most careful about making more direct copies of products that exist.
Okay, makes sense. Okay. Right, so that's when you get a complaint. How about if you have your eyes open and you see a seller who could be infringing on your patent or trademark, what does that look like?
You mean the process of making an IP complaint?
Well, I suppose we were on the defense before with someone else launching a complaint against us. If we notice that someone else is doing that, or there's just a rogue seller who's got some of our inventory, or here's a good one. Even I don't know if you see these cases, but it's pretty common to have listing hijackings, right? Off of So I don't any thoughts on the hijacking or just protecting your IP on Amazon?
Yeah, I mean, what I do is I refer to an attorney that handles that.
Okay.
I don't actually do shutdowns.
Yep.
And I advise a lot of clients when they get shut down about whether there's a real IP claim or not. But the nuts and bolts of handling the shutdowns and the defense with Amazon is a specialty all in itself.
Yep.
There are some great guys that do that, and I refer people to other attorneys that do that portion of it. And again, though a lot of times it's like when a client of mine has a potential issue with another seller, they're wondering about doing a shutdown. They're wondering if they can shut them down. I mean, I'll take a look to see if it's infringing, to see if they have a legit claim.
Right.
And then from there, we have someone else handle the nuts and bolts of it.
Right. Okay. Yeah, makes sense. Yeah, it's I guess we've found the end of the scope there, because that's an Amazon platform specific thing. Less IP, more. Yeah. Okay.
Yeah.
Got it.
It's very paperwork intensive. So the best people that do those are people that handle a lot of Amazon disputes.
Yeah.
Because they have the system set up with paralegals and other people that can do the non-lawyerly stuff less expensively, more efficiently.
Right.
I'm not the cheapest option for any of that. So I typically recommend to clients that they go to someone who has a system to do that efficiently and inexpensively.
Well, yeah. As I tell people coming into our service, you get what you pay for. So
right.
Yeah.
And you specialize in what you do. I mean, my specialty is patents and trademarks, and understanding where people can be protected and whether they should be protected, and advising my clients and taking appropriate action to get them protected. So that's what people ought to be paying me the big bucks for. But the other stuff, there are better options.
Okay. Yeah, Rich, did you want to, on that note, I guess, did you want to tell people where they can find you, how they can get a hold of you for their IP needs on Amazon?
Yeah, well, where you can find me is at a lot of Amazon and e-commerce related events.
Right.
I like speaking at masterminds in particular for smaller groups of Amazon sellers and helping them understand IP and how that works, and speak at bigger events as well. And I attend a good amount of conferences in this field. So that's where you can find me. In terms of learning more about the patent process, a couple of things. I wrote a book. The American Bar Association asked me to write a book explaining patents in plain English, and that's what I did.
Okay.
It's called the ABA Consumer Guide to Obtaining a Patent, and you can get it on Amazon, and it's pretty inexpensive.
Okay.
And also, if you want to learn more about patents through videos, I have a lot of great videos on my website that really break down the process. And my website is goldsteinpatentlaw.com.
Yep.
And that's probably a great place to go. And of course, if you need help with any of this, go to goldsteinpatentlaw.com and you can talk to my staff and find out if it's a match for us to work together.
Yeah. It's a very clean, well polished site, and I was on it just now. I guess so. That sounds great, and so that's where Rich will be. I won't see you at Prosper this year, but may let someone else from the team have their turn. But I'll see you around, I'm sure.
I'll be at Prosper. I'll be at I'm speaking at Celicon. I'll be speaking at a few other events too this spring, and so we'll bump into each other, I'm sure.
Okay, nice. Rich, so I guess any last words for sellers on their way out the door here? Any parting advice or things that you'd like to leave them with?
Yeah, I'd say probably the the thing I most want to leave them with is people are going to copy the things that you have, and sometimes you can do something about it, and sometimes you can't. And it really pays at an early stage to figure out if you have something that's worthwhile. Is it different enough that you're going to get a patent that's worthwhile? Is it a patent that's going to be useful to you in shutting down your competition? And to make that determination at an early point. And then, as I said before, then move on. Then focus on the things that are really going to make your business work well. So protect it when it pays to protect it. And if it does, and if it doesn't pay, then just focus on your business and rock and roll.
Right. Okay. Rich, Goldstein Patent Law. Thank you so much for coming on the show.
Oh, thanks so much. Thanks for having me.
Okay, I'll cut it there. Let's just see here.
So what do you think?
That was awesome. I think yeah. I'll send you. We have the video version. I'll do some sort of text synthesis as well. Actually, I'll make sure this is saved here.